Mr. Culberson.
Thank you, Mr. Chairman. Mr. Attorney General, the Miranda case, of course, is designed to preserve the admissibility of evidence in a court proceeding. Do you believe that Miranda is essential in order to preserve the admissibility of evidence in criminal court proceedings against the, for example, these enemy combatants brought to trial in Article III courts?
Well, it depends on the situation. For instance, that initial interaction with Abdul Muttalib, there was not the need for Miranda warnings under the exception to Miranda, the public safety exception. There are a number of exceptions to the Miranda rule that I think are appropriate and that law enforcement can use in questioning, gaining intelligence from
Excited utterance.
Excited utterance, the whole variety of things. The Supreme Court said not too many years ago that the Miranda warning regime was of constitutional dimension. 7-2 opinion, I think, or something like that.
You mentioned a moment ago, sir, that the people on the scene made the decision to provide Miranda warnings to the Christmas bomber. I just want to confirm that if I understood you correctly. Who did authorize the Miranda warnings to be given to the Christmas bomber?
That was done by people on the scene, but although I was not involved in that, I think that decision was correct.
And the purpose of the questioning, if the purpose of the questioning of an individual is to gather intelligence, are they entitled to Miranda warnings?
Well, again, it depends. I mean, a byproduct of the questioning that was done of Abdul Muttalib, justifiably done under the public safety exception, was the acquisition of intelligence information while we were also trying to determine whether there were other people in other planes, other people in the same plane that he was on. You know, I've heard a lot said about, you know, he was only questioned for 50 minutes. That's a fairly long period of time, certainly not as long as what has happened subsequent to that. But if you look at the report of interview that was gotten from him in that 50 minutes, an hour, there was a pretty substantial amount of information that was received from him that proved to be actionable, that proved to be timely, and that continues to be, at least in some ways, the basis for a lot of the cooperation that he has shared with us.
Since you've made the decision to try KSM in a U.S. court, wouldn't all of his incriminating statements be inadmissible because he was not advised of not giving his Miranda warnings?
There are, this is something I really can't get into too much. There are a variety of statements that are available for our use in that trial, some of which have no Miranda issues at all.
So when he raises the objection, as he will, when he is brought before a federal judge, that when his lawyers raise the objection that he was not given a Miranda warning, what will be the position of the Department of Justice?
In the Article III trial that we would present, there would not be a basis for a Miranda challenge.
Mr. Chairman and Mr. Attorney General, this is why this is such a, I mean, this is just one piece of why it really is a sincere concern to the people of Texas that I represent, to me, my colleagues, that if the approach of the Department of Justice and the Obama administration is that this is a law enforcement action, that in this war on terror is in fundamentally a law enforcement action like the war on crime, and it is not. We are at war, and Texans understand when you're at war, the goal is to hunt down your enemy and kill them or capture them. And in particular, in this case, this war requires that the President of the United States, as Commander-in-Chief, be given full discretion and authority to use whatever tools are at his disposal, as the Supreme Court has ruled repeatedly, that, and specifically referring to the Hamdi versus Rumsfeld case, the Supreme Court said that in reversing the Second Circuit Court's decision in Padilla that a citizen of the United States, quoting the Supreme Court, no less than an alien, can be, quote, part of or supporting forces hostile to the United States or coalition partners and engaged in an armed conflict against the United States. And if a U.S. citizen, if released, would pose a threat of returning to the battlefield as a part of the ongoing conflict, then that U.S. citizen can be held in detention through the military tribunal system, and because we're at war, and that's my concern, and it's a very deep-seated and earnest, profound disagreement with the approach of the administration that this is not law enforcement. We're at war. And you've, as Mr. Wolf quite correctly said, through the KSM case, set the precedent that when Osama bin Laden is captured, and you didn't answer the question directly, but it is a very legitimate one, if Osama bin Laden is captured alive because his role is equivalent to that of KSM, would you try him in a civilian court?
As I said, I don't expect that Osama bin Laden will face justice in a military commission, in an Article III court.
Right.
That will.
Odds are. But if he is captured alive, where will he be tried?
Again,
if he's captured alive.
I think that is speculation. You're asking me to speculate about something that, on the basis of all the intelligence that I've had a chance to review, the possibility just simply does not exist.